Hello everyone and welcome to today's webinar where we will look at the ins and outs of the complex world of workers' compensation. My name's Sue Mitchell and I'm the National Sales Manager for Australian Business Consulting and Solutions, and I'm joined today by today's panel of experts including Peter de Groot, independent medical opinions, Dr. Tim Anderson, our occupational physician who frequently works closely with IMO, and last but not least, Kerry Foster, Managing Director of Active OHS Solutions. Now, before we start, I ask if you have any technical issues that you contact Redback Conferencing directly on 1800 733 416. And if you have any questions for the panel during the course of the presentation, we have received some questions already, which is great, but please type into the chat box any new ones on the left of your screen, and we will endeavour to get to these at the end of the presentation where we have allowed some time for them to be answered. So without further ado, please let me pass you to Peter from IMO, who will start off today's presentation. Peter?
Well, good afternoon. Thanks for having me. I have been asked to provide you with some insights in the management of workers' compensation claims, and I understand that the audience may vary from people with interests in occupational health and safety, human resources, claims management, and workers' compensation legislation. Therefore, I have to admit that this is a bit of a challenge to just give you an overview of workers' compensation. And I will have to see myself obliged to limit my expose to 20 minutes. And that means that the picture I'm going to paint will be somewhat simplified for the sake of time. And my apologies for that. I will use my time to, first of all, set the boundaries of my talk. I will then briefly talk about the injury claims process. And finally, I'll explain how IMO is involved in this process. First of all, the invitation talks about or makes reference to the workers' compensation market in general and to workers' compensation claims in general. Now in Australia there are, as most of you most likely will know, three different schemes in the workers' compensation market. There is, first of all, WorkCover, that may be known in different states under different names. Then there is ComCare, and then there is the Seafarers Safety, Rehabilitation and Compensation Authority that regulate this workers' compensation market. Now, I will limit myself to the New South Wales WorkCover market. And you may know that there are different schemes in different states and territories. The New South Wales workers' compensation market is governed by the New South Wales government, whereas the ComCare and Seafarers schemes are governed by Australian government. Now, what is the role of WorkCover in New South Wales? WorkCover New South Wales is part of the Safety, Return to Work and Support Division, which was formed under the Safety, Return to Work and Support Board Act 2012 of 1 August 2012. The purpose of New South Wales WorkCover is to increase the competitiveness of the New South Wales economy through productive, healthy and safe workplaces. WorkCover promotes productive, healthy and safe workplaces for workers and employers in New South Wales. New South Wales WorkCover regulates and manages the workers' compensation scheme in New South Wales. The scheme is funded through premiums paid by employers. It provides medical and financial support to injured workers. And typically an employer will take out a workers' compensation policy by contacting a WorkCover appointed insurer. These insurers are referred to as scheme agents. So there are currently 7 accredited scheme agents in New South Wales. And mind you that there are different pathways in New South Wales, but I'm sure that this basic overview will not apply to all members of the audience today. I'd rather limit myself to this scope here. Now, WorkCover stipulates quite clearly what the process is to claim an injury, and the process is that every employee is bound by it, and no matter the severity of the injury, no matter what the injury results in a claim or not. Ideally, this step is to be avoided, as in to claim and I understand that today's speaker, Carrie Foster, will enter more into detail about how this can be done, the avoidance of a claim. And I'd like to attract your attention that one important document in that whole process is the certificate of capacity. The nominated treating doctor, which normally is a general practitioner, is required to provide a certificate of capacity rather than a sick leave certificate. And I personally see this as a big change to the past. So the new certificate is focused on what the patient can do rather than what he or she cannot do. And evidence shows that staying at work or returning to work promotes recovery and leads to better health outcomes. I may not be telling you anything new by stating that most of these incidents will not lead to extended absenteeism. Only a smaller percentage will result in a claim. That claim will then be managed by a scheme agent. And in those cases, the workers' compensation scheme will provide medical and financial support to the injured worker. Only in a very small percentage of cases, and that would be the last line in this little overview here, is where my company, IMO, gets involved. In those cases, there are process issues. Now, what issues could there be? First of all, most important, one of the two important issues are, first of all, disputes about medical issues, where there is, for instance, denial of liability, or there is request for additional treatment, for instance, surgery. The second issue could be that there is need for a permanent impairment assessment. The best example is John, who is a bricklayer, who falls off a ladder, climbing up and down scaffolding, and is left with a broken knee. Now, obviously, that knee will heal over time, but it might be that John is left with loss of use of that knee, or at least limited use of that knee. In other words, he is left with a permanent injury. That permanent injury will have to be assessed at one point in time. Medical disputes are assessed by workover approved medical specialists. These medical specialists will have an in-depth knowledge of the New South Wales workers' compensation system. And permanent impairment is assessed by a registered medical practitioner who is qualified in a relevant medical specialty. And this registered medical practitioner will have completed a training to use the workover guides for the evaluation of permanent impairment. At this point in my presentation, I'd like to move on to the role of my company in this process. IMO is the intermediate between the scheme agent, the specialist, and I've used the word medical specialist in loose terms. It does not necessarily have to be a medical specialist. And thirdly, the injured worker. Starting point is a claim for compensation for personal injury, and the market operates under the watchful eye of New South Wales work cover. What you may notice here is that the employer does not appear in this little scheme. My company, Independent Medical Opinion IMO, does not communicate with the employer. That is in the hands of the scheme agent. Now, what do? We provide services to a pool of roughly 400 independent specialists. A large number of these specialists are accredited to provide independent medical legal advice to scheme agents in the New South Wales work cover scheme. IMO offers back offices to these specialists, such as appointment booking, provision of medical rooms all over the state and the whole of Australia, interpreter services to the claimant when needed, dictation system, transcription system, bookkeeping services. And then to the client. Clients typically are scheme agents, but also larger employers, life insurers, solicitors, motor vehicle accident insurers. IMO helps these clients in choosing the right medical specialist, and our role is to manage a part of the claims management process. We deal with the doctor, the medical secretary, so that a claims manager does not have to. This slide describes the process that IMO manages. IMO holds time slots of numerous medical specialists all over Australia. Our call center team will receive phone calls from claims manager, scheme agent, with requests for appointments with a medical specialist to, for instance, assess permanent impairment for an injured worker such as John. IMO will then book that appointment with the appropriate assessor. IMO will make a consultation room available. Paperwork related to the matter is collected. That paperwork is all collateral information that will provide the specialist with a background of the case at hand. Most importantly, there is a referral letter from the case manager, which is a case manager dealing with a claim within the workers' compensation agent. This referral letter will set out the aim of the assessment, and questions are: what injury or condition is or was the worker suffering from? What is the cause of that injury or the medical condition? Is the injury or condition caused by an accident or by work conditions? Has the accident or work in general aggravated an underlying condition? Part of that paperwork may be x-rays, reports from a treating doctor, specialist reports from the surgeon that may have provided surgery, sick leave certificates, treatment reports of hospital reports, blood tests, and this collateral information may sometimes consist of hundreds of pages and many documents that our medical specialist will have to go through to form an independent opinion. The specialist will then have a consultation with the claimant. Findings will be dictated, transcribed, proofread, and IMO will then dispatch the report to the client together with an invoice. This process differs significantly from a clinical assessment. Please note that the consultation is with a claimant, not with a patient. So our medical specialist is not a treating specialist. He or she does not do an assessment, does not provide treatment, but does an assessment of the injury only. So the role of the specialist is forensic, not clinical. The assessment is a method of gathering and examining information about the past. The doctor's opinion is an expert witness opinion. The word of the claimant needs to be challenged on its merits, and this is what the collateral information is for. IMO has provided these services to the medical specialist and the insurance industry since 1991. We have over 20 years of experience in this field and have provided over 500,000 reports and assessments during that time. Traditionally, we would receive requests for assessments of mainly soft tissue and bone injuries. Specialists asked were orthopedic surgeons, occupational physicians, rheumatologists, neurologists, or neurosurgeons. But increasingly, we see a demand for psychologists and psychiatrists. Now, psychological injuries we're asked to assess are numerous, and I'm quite sure that a lot of the members of the audience will have been confronted with some of these injuries, such as chronic pain, post-traumatic stress disorder, depression, anxiety, adjustment disorder, even chronic fatigue syndrome. Mind you that I've mentioned stress here under the heading injury. I have to underline that stress is not an injury or a medical condition, it's merely an environmental condition or situation, and I'm aware that stress is often used as a reason for absenteeism. One question I'm quite regularly asked is, why is there this increase in the incidence of psychological injuries? And the first argument I hear is that life is more stressful today than it ever was. For myself, I'm happy that I live in Australia in 2014 and not in the dark Middle Ages, but that is just my view of life. The good thing is that there is a decreased stigma and an increased awareness of psychological issues. It's just more easy today to talk about these issues than it ever was. But on the flip side of that, there is a higher incidence of self-diagnosis, and there is a possibility of over-medicalization, and also there is an ease to, it is easy to feign these sort of injuries. Just for the sake of the exercise, I have Googled the question, what are the symptoms of a depression? And here you have 8 symptoms. You can imagine that it is quite easy to memorize 8 or perhaps 6 or perhaps even 4 of these symptoms, present them to a general practitioner, and to be diagnosed with depression. The general practitioner has an obligation towards the patient and has no reason to believe that the patient is not telling the truth. This, however, is very different for the independent medical assessor. The independent medical assessor is confronted not with the patient but with the claimant. That claimant now has a monetary interest in being diagnosed with a compensable injury. I do not mean to put a claimant in a negative light. I'm merely trying to make you aware of the difference between the roles of a treating doctor and an independent medical assessor. We're in a very different field of medical injury. This leads to the question, how can we objectively and independently assess a medical or psychological injury? Now, I'm not a practitioner myself, and I'm not the right person to answer this question. I can tell you that there are numerous tests available that can assess psychological injuries. I've just listed a couple of them here in this overview and would like to leave it to that. I believe that this may be a question for next seminar altogether. I'd like to thank you now for your attention and would like to hand back to today's facilitator, Sue.
Thanks, Peter. Appreciate that. Well, let's keep going. And Tim, over to you.
Thank you, Sue. Hello, everybody. I've got 10 minutes to go through a few issues here that just get your slides up. There we go. Clinical complexities. Now, before I start, I just say that this is purely my view on things. There is no intention at all to criticize anybody, anything, any issue. These are merely observations as they come across. Now, one of the first ones is that by the time I see an injured worker, a lot of water has gone under the bridge. And often I see somebody who comes into the consulting room and they're really rather fearful. Usually this is a first occasion that somebody has been through circumstances like this. They don't really know very much about it. They're terribly frustrated, and often they can be quite isolated. Now, isolation does not always happen at the time of the accident or thereafter. It is sometimes very much later during rehabilitation phases. And all too often I hear of people going back to work or trying to get back to work on a graduated program, and they're literally being treated like medieval lepers. Now, that's something that isn't going to help very much at all, and it's something that we really have to look out for. Now, the other thing that I come across is the state of fitness of many of these people. Now, these are wonderful pictures here that show the sort of what we would like to be on the left and what we sometimes see on the right. There are all sorts of programs these days about obesity and health and fitness and giving up smoking and blood pressure week and cholesterol week. I haven't come across hemorrhoid week yet, but no doubt that'll be on the cards fairly soon. One of the things that does happen when somebody has been injured is that very soon after that, their level of physical fitness drops to an all-time low. And whatever else happens, however they're treated, however they're rehabilitated, that person does need an element of physical fitness to get back on the rails and start doing that job again, whatever it is. All of us involved in this presentation, for example, even though we spend most of our time in our offices, still have that basic level of physical fitness in order to do that. Now, that's very different to the sort of fitness that, for example, the process worker that I saw earlier in the week, who was a little bit taller than me, but he weighed 142 kilograms. He was the nicest guy in the world, but he had a problem with one of his knees. Is it any wonder? And is it any wonder that the knee is not getting better quickly? And he was described as a process worker. And in fact, he was doing all sorts of other things. I'll come back to that later if we've got time. One of the things I would like to see more of is control. And the sort of issue here I would like to see control by is the HR people, you people. Who pays for all of the insurance that covers your work team? You do. And I think that you should have a bit better control over what goes on. Now, sometimes you'll be lucky and have a good case manager who has a clinical background, and that makes it very much easier when you're dealing with clinical issues. sometimes that person does not have a clinical background. And that leads us on to the sort of questions that I sometimes see in referral documents. I would like to think that HR, the employer's HR, and don't forget that you are the face, the workers' compensation face, if you like, of the employer. The buck almost stops at your door. I would like to see HR having a greater influence on what goes on with the case manager, with the insurance agent. Treating doctors. Now, another thing that we find is that people sometimes get channeled into situations where they could be done a bit better. Now, one of the first things is that if the injured worker is able to go to his or her own doctor, there will probably be a better level of rapport. Now, if, for example, we're dealing with something like a shoulder condition, just consider if we're going to send that person to a specialist. And in most cases, if the person has a damaged shoulder, we will probably need to do that. Have a think about this. Wouldn't it be better if that person is referred to a shoulder specialist, not a general orthopedic surgeon, but one who specializes in shoulders? If it's a hand surgeon, if it's a knee surgeon, an ankle surgeon, and so on, depending on what the issue is. Now, these are subspecialities, and there are plenty of these excellent specialists around. It basically answers the question is, where do you take your Rolls Royce to have it serviced? Do you take it to the local garage down the road, or do you take it to a specialist? We would like to take it to the specialist and to the right specialist. Now, to take that on a little bit further, there's quite a lot of downtime occasionally with these specialities. And if the person goes to that specialist, the specialist will probably say, yes, you've got a problem with the shoulder, I'm not quite sure what it is, we need an MRI scan, and come back and see me. It's going to be far better if we can get that MRI scan done before the person fronts up to the specialist, so that the specialist can see the person with the claim then and there and start discussing what is the best way of treating it. Don't forget, we've got something like 6 months. And then if that person is not back doing their full job, there is a very real chance that the person might not have a job. So therefore, we're looking at referrals. And I would love to see HR getting involved with the treating doctors and saying, look, Mr. Brown lives in such and such a place. We know he's got a problem with a shoulder. We've done a little bit of research. Here are the name of 3 specialists with shoulders who would be able to look at him close to where he lives. Right, let's just move on a little bit and bring up the next one. So therefore, if we start looking at some of the principles as to how we would start looking at these people, we've got somebody who's frightened. Let's start with explanation. If the person is in hospital, could we possibly visit the person in hospital? Maybe, maybe not. But it would be a good idea to phone them up. Some of the things that I get told is, oh, they don't care about me. Nobody cares about me. Nobody has asked anything about me at all. They just don't give a hoot. Education on what has happened to the person is something that is going to be very good indeed. Now, what is the person going to be doing if he or she is off work for a protracted period of time? Far too much they become couch potatoes and do the square root of not really very much at all. It would be far better, I think, to have some kind of program, a training program for this person, so it could be in anything. Almost anything at all, but to try to keep the brain working, get them motivated, get them thinking. Honesty is something that we must have, and we must be seen to be providing honesty and consistency and persistence and humanity. This means just basically treating people like human beings. Communication, you've heard a good bit about communication from Peter so far, and you're going to hear a lot more from Kerry. I would just enhance what they have said and are going to say, that communication is one of the most vital issues that we have. Constantly talking to people. Now, as the HR representative, you're in an excellent position to keep tabs on the case manager, the treating doctor, and the person making the case. Know your case is absolutely vital. Sometimes I get referral letters, and the questions in these are really very inappropriate for the particular circumstances. Early recognition, this is a thing that was actually turned on its head yesterday. If you get somebody who's had a severe back injury with surgery that subsequently follows, it is almost impossible to get that person back to a physically arduous job. Strange as it was yesterday, I actually came across a case where a fellow had had a back injury and had actually gone back to a physically arduous job, concreting, fixing, reinforcing bars and tying them, and he'd actually gone back to do this and was still doing it. But the problem with him was that he was starting to deteriorate much more rapidly than he should have. And this is another thing, early recognition of issues like that. Will that person ever be able to get back to do that kind of job with this condition and the sort of treatment? If that's the case, early recognition is going to put us in a far stronger position to start addressing that and doing something about it before things develop into a whole load of psychological and psychiatric issues that Peter has mentioned. We must take responsibility. HR, yes, you're the employer representative. You must have some responsibility with this, and obviously the worker must have responsibility as well. It's a shared responsibility, and then we come back to communication at all. We must keep talking about it. Timings is very important. If there is delay, we get all sorts of problems happening, and the longer these things are delayed, the better. I mean, the worse. Sorry, wrong way around. One thing I just wanted to mention there, let's just go on to this one first. Yes, here we've got it. The public list. If we've got a person who's to be seen by a specialist, and the issue is subsequently described as not being a work-related workers' compensation case, let's start making moves to have that person put on the specialist's public list rather than delay. With the public list, there can be cancellations and people can come up for review by a specialist sooner than we might think. It's certainly worth considering. Relationship with the GP is absolutely vital. We are not trying to tell the GP what to do or how to do it, but if, for example, as in another case I came across yesterday, certificate of capacity for work was for 23 hours a week doing 2 completely different jobs, I'm rather curious as to where that 23 hours comes from. All of us must be able to give good reasons why we make good decisions, or any decision. Case manager, we mentioned about worksite visit. Now, this is very good. One of the things that, as an occupational physician, I sometimes do is visit work sites, whether it's in a hold of a ship, heavy industry, or a chicken farm. These are some of the places that I have been not all that long ago. With a worksite visit, we get a far better idea as to what that person is supposed to be doing, and also whether we can maybe make helpful recommendations getting that person back on a graduated return to work program. I think worksite visits are very important, but if we do worksite visits, one thing that is very important as well is it's jolly good to be able to take photographs. A picture speaks 1,000 words, and so it is with this sort of situation as well. Job description. Can this chap go back and be a process worker? I can't tell you unless you tell me exactly what being a process worker is. My nice young man of earlier in the week who weighed 142 kilograms was described as a process worker. He wasn't actually. His job was undoing different cables, carrying out a modification to them and doing them up again and carrying out various welding processes on it. Now it was on a bench, but it was fairly heavy work and he needed strong arms and wore gloves to do it. This material was then used in the mining industry, but nobody had told me exactly what he was supposed to do, and he had difficulty explaining that as well because he came from overseas and communication was not all that good. Confounding factors. I think this is the last one I've got, so I'm nearly at the end and I must be fairly quick about that. Things can get awfully pear-shaped. Failure of communication is one of them. Compliance. I'm usually asked about treatment, to comment on treatment and to make recommendations. I'm very happy to do so. One of the things that will not assist is passive massage-y type issues. These will not fix anything. Sometimes it might assist a little in control of pain and discomfort, but it certainly won't help to fix things. If we've got somebody who's had a problem and they are physically not doing very much at all, we really must be looking at exercise, exercise, and after that, exercise again. And the best person that I've found who can do this, who can advise on it, is an exercise physiologist. Now, I think the sun shines from the ground that some of those people stand on, and they can be extremely effective. You don't need a gymnasium. You do not need a gymnasium-based program. What you do need is a home-based program, self-managed, supervised initially by the exercise physiologist. Put it in an exercise and progress diary. Complete that diary. The worker completes that diary, always doing it, always progressing, always doing just that little bit more. That diary should be available for review. You should see it. So should the exercise physiologist periodically. Let's keep control of things. Let's keep our finger on the pulse. Constitutional conditions. Invariably, after about the age of 30, we do have progressive increasing degenerative changes. These things can be made worse. They can be made permanently worse. There's the argument over whether it is an aggravation or an exacerbation. If we just say, is it permanent or is it temporary, we're going to be far better aware of what exactly is going on. Side effects of medication. There's that awful drug Lyrica. That's the trade name. Pregabalin is its real name. Sometimes people are on that for the management of chronic pain, which is this one at the top. Very difficult to deal with, very easy to talk about, but very difficult to do anything constructive about. But oh yes, Mr. Brown can drive a whatever it is. Well, can he drive that with a heavy dose of medication on board? Possibly, but certainly possibly not. So these are things we've got to watch for. And that, I think, is just about compliance. Last one. Sometimes I see a case on several occasions, and I can remember one case. I shall call her Dear Mrs. Brown, and I wrote all sorts of exercises and stretches that I thought she should be doing. I saw a couple of years later, I asked her, had she been doing anything like this? No, she had not. And in my report, my second report, I wrote back, Mrs. Brown's exercises would be much more effective if she actually did them. So that is some of the things that I get. As I say, this is not a criticism. It is merely observations from my perspective. So thank you.
Thanks very much, Tim. Now, before I hand you over to Kerry, I just want to remind you all that you can post questions. Don't forget, you can put them in the chat box on the left-hand side. So over to you, Kerry.
Thank you. Thanks, Peter, and thanks, Tim. And Tim, that was a perfect segue into my presentation, which is all about employers taking control of workers' compensation. Before I start, I'll just let you know that I've been doing this for about 25 years, so I do have a lot of experience in the workplace rehabilitation arena. And just to follow up on some of the things that that Tim was talking about, the medical situation definitely needs to be well managed, and one of the things that, excuse me, I just got to get this to move on. One of the things that I always recommend to employers is that they actually look at getting a medical advisor, a company medical advisor, rather than relying on the general practitioner. So I hope you're not too bothered about that, Tim. What I also find is that a lot of employers do not understand their premium drivers, and are sometimes shocked to see when their premium has gone tripled, quadrupled, sometimes has gone up so much in 1 year that it could actually put them out of business. So I hope at the end of my presentation, you'll have a little bit more understanding about what you need to do to make sure that that doesn't happen. Just move on. So certainly this was the message from Tim, and I can't stress enough that if it's the HR department, that there is certainly a return to work coordinator. That is required by law, by the way, if you have a premium over $50,000 per annum, that you have a trained return to work coordinator or someone who is responsible for what happens when someone is injured, or if someone is even reporting an ache or a pain. As I mentioned before, organising a company medical advisor, I think, is something that I recommend always to employers. And the best practice would be to actually have the person, the moment they report an ache or a pain, or certainly an injury, that they are transported by the company to your company medical advisor. That does not mean, I hasten to add, that company doctor, the person has to appoint that company doctor as their nominated treating doctor, but in 9 out of 10 cases, in my experience, and what I hear from employers, is that they do actually nominate them. And so you do actually have someone who understands workplace rehabilitation and occupational health, looking after your people, which is along the lines of what Tim recommended for when you're looking for specialists. Certainly communication and avoiding conflict. You may not agree with what's happening or the workers' compensation legislation, but you, as they say, you catch more bees with honey than vinegar. So if you must communicate and provide that injured worker with support. Suitable duties is critical. Even if you feel you don't have them, you must offer them without fail, because getting back to those premium drivers, sometimes, and in fact often, depending on a very complicated formula, it can be actually more expensive to have that person sitting at home than having them at work. And the other thing is that you expect them back to work, or actually the new buzzword these days is stay at work. If you can possibly avoid any time off, then you're actually ahead. So how can you prevent an injury or a claim? As I just said, act on aches and pains, because they become injuries. If you have an incident notification book, which in fact you're required to have by law, then have someone reviewing that, perhaps the return to work coordinator, who will look and see that so-and-so is reporting that they've got a sore arm after working on process line number 1. Well, best practice is actually to investigate that before it becomes a problem, and that's money well spent, because it's less likely to become an injury, and it's not going to be premium impacting. So investing in prevention, I'm sure that if you're working with Australian business, that you're aware of their WHS services, and that's obviously, prevention is obviously a lot better than cure. Supervisors, in fact, I just recently was at a conference where Professor Steve Linton spoke, and his most recent research is around the workplace, and without fail, he found that supervisors are the most critical factor in a successful return to work and also a positive workplace. So training supervisors to take their obligation for WHS and return to work seriously is obviously money well spent. And supervisors should also be aware of the premium drivers. And even better, if you can drill down and make it cost centres, so supervisors are directly responsible for people who are off work, and the longer they are off work, the more it's going to impact negatively on that cost centre. There's no doubt about it that you need to closely manage all claims, and I hasten to add here that one of the worst things you can do is to rely on your agent. Work cover is actually the insurer in workers' compensation in New South Wales, and so what you know as the workers' comp insurer is actually an agent of work cover. So it's not their money on the line. It doesn't come off their bottom line if your premium increases. I always say if you don't understand premium drivers, then engage someone who does. It's not my area of expertise. claims management and the way they calculate premiums, but I do work with a lot of specialist workers' comp brokers who can assist you with that. Consider pre-placement medicals. They're certainly not a panacea, as I'm sure Tim would agree, but they do give you an idea. It's a part of a risk management approach, I guess. And the question is posed here: what should you do if someone is injured? It's basically to take control. And certainly if you haven't got them to the nominated treating doctor, if you haven't got them to your company medical advisor and they have appointed their own doctor as the nominated treating doctor, a lot of general practitioners don't actually understand workers' compensation. It's about, I've seen a statistic, and Tim might be able to add to this, it's a very small fraction, less than 10% of their practice, so it's not something that they're very skilled in. So they don't actually understand, for example, that they have a legal responsibility to participate in the injury management and return to work process. If they're not communicating with you, then advise your agent. This is a situation where you should advise your agent and should rely on them, because in the legislation it is written that if a nominated treating doctor is not participating in the process, you can actually get them removed from the case. That's obviously the last resort, a sort of last resort. The best thing, as Tim said, is to communicate, and you might want to arrange a case conference and to attend the surgery and discuss the case with the nominated treating doctor, and certainly reinforce the company's commitment to early return to work. If they're not communicating, though, regard that as an alarm bell that this is a case that is probably not going to go well. The changes in the legislation in 2012 did give some hope or some sort of tools with the concept of work capacity, but if you've got a difficult doctor, then it's still going to make it very hard or much harder to get that person back to work. And remember, the longer someone is off work, given that wages are the biggest component of any workers' compensation claim, the more it's going to impact on your premium. If it is looking like a difficult case, then you might want to consider a referral to a workplace rehabilitation provider. A workplace rehab provider such as Active OHS is accredited by WorkCover New South Wales and employs specialists like occupational therapists, physiotherapists, psychologists and rehabilitation counsellors. So you're having someone who has a higher level of expertise examining the workplace. Just going on to the next slide. So suitable duties are really important. As I suggested before, being creative, even if you don't think you've got any suitable duties to offer and that you're just going to have the person twiddling their thumbs, you need to be creative. And as a workplace rehab provider, I've certainly gone to workplaces and walked in with them saying there's absolutely nothing we can offer, and walked out with enough to write a suitable duties return to work plan. And it's things like filing, for example, that has been sitting there and no one's been doing it, or stock taking, or there's a whole raft of things that you could consider. As I've noted there, the second point, there's a strong link between time off and the failure of return to work. There is no doubt that the longer someone is off work, the less likely they are to return to work. The other thing that I certainly encounter in my work is having people off work or not having very strong policies and procedures in place to keep people at work. The workplace can see it as workers' comp as an opportunity to have time off. And I once was called into a workplace where there was 16 workers and 4 of them had long-term workers' compensation cases where they, including the supervisor, by the way, where they were just taking time off as they needed. It's a good way to top up your sick leave, for example. I do also hasten to add, as Tim said, that I'm presenting sort of worst case scenarios here. It's always better to approach workers' comp and return to work in a positive manner, and keep that goodwill in the workplace. I'm just moving on. Oh, that's it. Oh, what if the case is complex? Okay, as I suggested before, if you are finding that the case isn't going as you would like it to, you can refer to a workplace rehab provider, and I will also add that you can refer directly to a workplace rehab provider. It's not something that you have to get the agent to do, and in fact, as part of your return to work program that is required by WorkCover, you should have nominated a workplace rehab provider and also, by the way, appointed a return to work coordinator. I'll say it again because it is so important. Delay to referral, or the longer someone is off work, increases the rate of failure of return to work. Where what a workplace rehab provider can offer is an independent party that is certainly important in the face of conflict. A workplace rehab provider has the expertise essential to ensure suitable employment and timely upgrades. There's someone who is totally focused on the return to work process, rather than someone like who's also doing payroll, and that obviously takes priority. And I guess as the workplace rehab provider, like everyone else at the workplace, is committed to a successful outcome. And I think that's me.
Great. Thanks, Kerry. Really appreciate it. Now, we've got a lot of questions, so I'm not sure that we can get through them all. So what I'm going to do is read them out, and Kerry, Tim and Peter, if you could nominate who's going to answer the question, that would be great. So one of the first questions that we got through from Eugene was, can you explain the wages paid to workers on suitable duties, i.e. where there's 100%, then 95%, and then 80%?
I can answer that.
Thanks, Kerry.
There's, under the new legislation, the 2012 legislation, they overhauled the benefit system. I will add, by the way, this is certainly not my expertise. I got it, although I am an accredited Return to Work Coordinator trainer and took this off the Return to Work Coordinator training package. It's based on the entitlement periods, and the first entitlement period is Section 36, which is 0 to 13 weeks, and at that stage, whether someone has current work capacity or no work capacity, they're entitled to 95% of their pre-injury average weekly earnings, or otherwise known in the industry as PRW. There's a bit more around that, but just in the interest of time, moving on to the second entitlement period, Section 37, which is 14 to 130 weeks. If a worker is rewarded with a higher weekly payment if they're working 15 hours or more per week, and that's 95% of the PRW. And if they're working less than 15 hours per week or have no capacity for work, it's 80% of their PRW. Thanks.
Now, one of the questions we got was, one would assume that most cases are genuine, but as stress is very difficult to measure, as you've all said, how should we handle cases that appear not to be genuine? Tim, do you care to comment?
I'll try. Very difficult one, this. You've got to communicate. You've got to start going through the whole thing from all different angles to try to work out what is driving this situation. There may be all manner of things. I said know your case. It's a very good idea to know a good bit more about the circumstances of the person without getting too nosy. For example, there may be other issues on the home front, family members who need support, who are ill, unwell, injured themselves, children who've got problems. If we know those things, and if we can tick off those boxes that those, if they exist, they are being managed appropriately, obviously not by us, but still being managed. If everything is ticked off, then we've got to get right back to the nitty-gritty again and go through everything. And again, face-to-face meetings, not knocking the person into the ground like a tent peg, but going through everything, every little bit, and saying, look, are you absolutely sure this is what you're talking about? And again, it comes back to really good communication. One of the things that Kerry mentioned was investigation of the injury. I think this is absolutely vital, that if you are seen to be investigating how the injury occurred in the workplace, and other people actually, other workers see you doing it, and the results are published on the notice board or something like that, you'll get much better response of the workers in the workplace in that employment situation.
Great, thanks, Tim. What do you think, to all of you, what is best practice to deal with injured workers whereby their claim has been declined? And I know this happens a lot.
Well, I would say they're still an employee.
Yep.
So you basically have to manage their return to work and support them. It's sort of like a big question if you don't know why the claim has been declined. But essentially, they're still an employee, so you should be supporting them to get back to work.
Great.
Can I add a bit on
Sure.
to that, please, Sue? I agree with Kerry. Again, it comes back to communication, explaining, educating people, and explaining why it is not being accepted as a work-related issue. If we can explain things, people are just going to be so much more confident in the system. Absolutely.
So, how can the use of investigations benefit the management of a stress claim?
Well, investigations are usually invoked when there's a claim, and we shouldn't be saying stress claim because it's a psychological injury claim. Stress is not an injury. So psychological injury is typically investigated when it's reasonably excused. So I suppose that gives you the facts, but equally I stand by my previous comment that if someone's claiming a psychological injury, whether it's real or imagined, you've got an issue with an employee that needs to be managed. So whether it's accepted under workers' compensation or not, you need to sort it out, basically.
Correct.
Can I just add, as part of this, I came across a very good publication by Safe Work. Oh no, it was actually from the UK, and I've got a table here. Then it's got management competency framework with positive and negative behavioural indicators for basically managing stress in the workplace. And I thought it was it lists you positive examples of manager behaviour and negative examples of manager behaviour, which I think is really useful.
Great. So we can put that up.
Yeah, I can send that to you. Yeah.
Fantastic. Thanks. Now we are running out of time, but just a couple more questions. I had one from a lady who's saying, how do you manage a workers' compensation claim once an employee has resigned from the business and it wasn't due to their injury? So they resigned, but they had a workers' compensation claim. Kerry?
They're not. Well, if they resign, they're not entitled to weekly benefit.
Right.
So I'm not. I guess I'm not clear about what else would still be impacting. I mean, if they are still being paid, this is a perfect example, which can happen, by the way,
yep,
where an agent just drops the ball. If they're still being paid, then someone needs to look really closely at why they're still being paid, because essentially if you resign from your pre-injury employer, then you are not entitled to weekly benefits, which is actually the major cost of any claim. So it would just be a matter of talking to the agent and maybe your broker about how to finalise that claim.
Sure. Thank you for that. It's interesting because a lot of the questions coming through is about, one of them was, there's so much cynicism around workers' compensation. How can we create a positive and supportive attitude to it? It's a big question, isn't it?
Well, I think it's about communication. It's about being proactive, and having a return to work program which is how we do business here. How we do business if someone is got an ache and a pain or an injury, and involving the return and involving the workplace in that, basically. And that is actually what is required by WorkCover, and there's a document called Guidelines for Employers for Return to Work Programs. It's available on the WorkCover website. Mm-hmm. But it's like taking control. We're going to look after you if something goes wrong, and we're going to make sure that you get back to work in an early, safe and sustained manner. I mean, that creates a very positive environment in the workplace.
And I think we've got time for one more. Does workers' compensation cover an employee who's employed and paid in New South Wales but who works mostly overseas?
I saw that one come through. I think I would say yes, they're covered by New South Wales. The tricky bit there, it's like a labour hire firm, because it's that employer needs to be has got a responsibility to ensure their health, safety and welfare overseas. So they should be getting information from that overseas employer about their workplace policies and procedures around health and safety.
Okay, great. And lastly, can employers insist on a rehab specialist even if they're not specified by the treating doctor? Yes.
Section 119.
Section 119. Thanks very much. Yes,
so can I come in on that one very briefly? Consider rehabilitation physicians as well. Sometimes I come across cases where a worker is still under the care of, for example, an orthopedic surgeon who is still writing out scripts for all sorts of different medications. Surgeons are there to do operations. Rehabilitation physicians are there to assist with the rehabilitation of an injured worker back to the workplace, and are much more appropriate than a surgeon if there is to be no operation. So to that end, I would suggest that these people that a worker would be referred by the treating doctor to a rehabilitation physician in difficult cases, and that the HR people could have a positive influence on making sure that referral occurs, because that rehabilitation physician will be giving an opinion on how much work that person can do or otherwise, and that is likely to be helpful.
Thank you. And so that brings us to the end of today's webinar. I hope it has given you a good understanding of all things workers' comp, and I'd really like to thank our speakers, Kerry, Tim and Peter. You've been brilliant. If you have any further questions for any of our speakers, please do contact them. Or alternatively, you can visit our website, australianbusiness.com.au, and we can see if we can assist your business with your workers' compensation requirements. Now, we're going to be posting a recording of today's webinar on our YouTube channel in the next few days, and we'll be sending everyone who attended a link so you can watch it. Plus, we've also got some further information for all of you, which you may find useful on this topic. Thanks again.
Thank you.